I haven't heard anything from him.
Okay.
Well, yeah,
keep it that way.
exactly. They want to,
They're cutting corn or something.
I think it's the second one, first one.
What's that?
They want
Who
to
gets hurt? He fell off it, fell off the truck. Collarbone.
make sense.
Focus collar.
But the one is industrial.
Thursday.
Lucky it's only collar.
Okay, we're live.
Okay, we're live. We're ready to go. Okay, I'll open the meeting. And the first item of business on there will be the approval of the minutes from September 22nd. You've all had copies of the minutes. Is there any comments or questions?
I thought that for years.
I'll move.
Moved by Dennis, seconded by John.
I will.
Remember that, the accident there? Oh, it's
Excuse me. All in favor?
Just put your hand up.
All in favor of the minutes? Thank you. And I would like to just say one thing. We wish the best to Doug Aldred. Doug fell off the tractor the other day and broke his collarbone and had an operation, I believe, on Friday night. And he's not able to drive or do anything right now. In a lot of pain. So wish him the best. And I haven't heard from John Andrews, so we'll just continue. Okay, the next one is about the OACA training videos for November 24th. And actually, open that, please.
Thank you, Mr. Chair. So we talked about this at the last meeting, I believe, and I'm just looking to confirm that we're all on board with it being the November LDC meeting in the afternoon after, and that everyone here can confirm their attendance.
Yes,
So far,
yes.
All right, so you get the videos for 3 weeks. And then if you need any longer than that, you have to contact Oaca yourselves and ask for an extension. So when would you like me to start the 3 weeks? You want me to do it like a week prior to the
week
meeting?
prior,
And then
yes.
Yeah, a week.
after? Like,
A week prior, like the week, say the 17th, by the 17th of November.
yes.
Is all the members?
You send them out to us and we review them before we come here then, or?
Yeah.
that would be up to you guys if you wanted to review them prior to showing up, but you could have that option just because they
Right.
are.
I thought we were gonna sort of meet here.
Right.
After that morning meeting
Yeah,
and watch them all.
yeah, yeah.
But if that's the first time we're gonna watch them all, then why do we need them a week ahead?
Just in case you want to review them before the actual meeting.
We can go through them in, at the meeting.
Okay.
Schedule them.
So we'll all get copies sent to us ahead of time. Okay.
Okay.
Good.
Okay. The next item is any inquiries from the Land Division Committee members on anything? And we're a little bit ahead there. So would the committee agree to drop down to review the meeting dates that are listed at the bottom of the last?
Definitely.
You all have a sheet with the meetings for 2022? Any concerns?
Any glaring errors?
I checked my.
Any,
and I don't have.
any Christmas that we need to know about or?
Chairman, quick question. That June deadline for submission is awfully close compared to the others. It seems to be a week later than the others. Is that normal?
That should be.
Should be like the last week of May or something like that.
No, that's, when the date for the submissions,
Yeah.
that's when, then we're back to 6 weeks, right?
Yeah.
I think that may have been.
Yes, because this was a 6-month trial period, right, for the 8-week submission. So we'll have to so that's basically reverting back to the 6 weeks it should be.
The meeting's on the 27th. They have to be in by June. For July, have to be in by June the 1st.
Yes.
So that's what the Wednesday, March 23rd meeting is about, to address that, whether we extend it or.
That's right. We'll have
Right.
to have that on the agenda to discuss continuing the 8-week submission deadline or moving back to the 6-week.
Yep.
Does the municipal election alter anything? Do the councils still approve them and pass them, or do they delay things, lame duck councils and all that? Is that is that effective? I'm not being
Isn't until next November.
appointed after the election, so I don't quite know
2022.
if there's any issues around a delay.
Election.
Through you, Mr. Chair, the election will be end of October, I want to say, 2022.
November usually.
I thought it was November, but I actually think it's earlier.
Are they moving it up?
So,
October, it was October, the last one too. The last Monday or in October.
23rd.
And that's when the election will be, and they take effect for the municipalities, takes effect the 1st of November,
Typically,
December.
it's around December.
Yeah,
around the 1st of December, right, excuse me, yeah.
county council put in
They
December.
all have to be, all the councilors will have to be, and the municipal councils have to be swore in before the mayors can come for the second week in December here for election of the ward.
yeah, exactly. So we'll find out, but I don't think it affects Land Division Committee because you're appointees, so,
Appointees.
Doesn't affect us, but we get the resolutions from council. Will council pass resolutions?
you mean the local municipalities? Oh, I guess that's something we can find out. I'm assuming there wouldn't be an issue, that they would be able to still pass bylaws, but I guess we'll have to,
Okay.
we'll inquire in time for that.
Okay.
Yeah, no, they'll be dealing.
The end of everybody's term.
Any other questions? Can we have a mover and a seconder? If you,
I'll move.
moved by John Selden, seconded Jack Van Castren. Any other questions? All in favor? Opposed? No.
COVID doesn't come back.
If we've got a minute, any updates on they were looking at making some changes or something around land division or appointments or planning or anything like that?
Through you, Mr. Chair, no changes that I'm aware of as of yet. So,
No.
also through you, Mr. Chair, the legislation that we've discussed, the changes to the Planning Act, as far as I know, has still not been proclaimed, so that continues to
Right.
sit at this point. The only legislation that's out there right now for review is there's some regulations associated with the Conservation Authorities Act that's come out for comment, and that's the last legislation that I'm aware of, so.
And I believe the one that put forward, Bill, something to look at saving farmland or something, that one about, there's one bill put ahead by a member and it's been squashed, I think, or it hasn't been dealt with at all.
Okay, gotten no readings, okay,
Yeah.
there you go. I guess we are ahead of time.
Any members got any other questions about anything?
Nothing to do with land division.
Well, staff, you guys, by chewing your head off over something that we might be able to help you with?
Just leave that. Just leave that
Leave
item.
that item off the agenda.
Well, I think Nancy and Ashleen have done an excellent job as chairman. I know they've done an excellent job, and it's been tough. I've fielded some questions from some people that just really have got to sit down and look at the rules and talk to the municipality before they come to us too, I think. Because there seems to be a bit of a rush. Is that right, Nancy, and Ashleen, to get some of these in and done?
Through you, Mr. Chair, I don't know, but we are seeing quite a few of them as of late, so I'm not sure if there's maybe a year-end consideration or something like that, I'm not sure, but, yeah. We have had quite a few applications and inquiries on application,
Yeah. But I think we have.
dealing with them as best as we can, so.
I think the staff are doing an excellent job where they have to own the farm and have other land before they can qualify to sever. And Nancy and Ashleen are doing an excellent job. They can't just think they're gonna buy that farm. Is that right, Nancy?
Well, there are rules and we're going to ensure that,
Your fault.
based on that, we will, ensure that the applications are done correctly then and that the information is provided correctly, so.
Question, Mr. Chair.
Yes?
Through you to Nancy. So have or to Ashleen, has the application been updated? We worked on different things. Is that now in effect?
Through you, Mr. Chair, yes, it's actually on our website as well, so. So we have, like a checklist, which is the start of the application now, and it ensures that for every type of application, you're aware of what needs to be submitted with that application type. And then the application itself has also been updated based on our discussions with legal and, the committee. So hopefully, there won't be any discrepancies coming forward, yeah. I mean, there still may be, we always know that there are ways to maybe, fill out applications, but hopefully, we're also, as the chair mentioned, will work with our municipalities, because oftentimes they're going to know the most up-to-date information or, ownership information, so we'll work with them to ensure that we have that information too.
Regarding ownership, do you as staff at the county level have access to the land registry office? Just quickly to see who's deeded on the property? How's that work?
Any inquiries at the land registry office is a fee. So we don't have that set up. We rely usually on the municipality because they have the most up-to-date property tax information typically, because they send their tax bills to someone. So we would be able to, normally, our system takes a while to catch up because our mapping system, we rely on information and we only get it, I think, maybe twice a year or something in terms of updates on the parcel information. Well, sometimes it doesn't catch up quite quickly. So, so sometimes we may not have the most up-to-date.
So a quick check with the municipality.
Is usually how we do it. Mhm, exactly.
That makes sense.
Yeah.
Yeah.
And in fact, some of them have submitted as well tax bills to show,
Right.
for instance, that it's been changed to their name. So that's helpful as well.
And excuse me, I forgot to introduce Brian Lima, county engineer and I believe deputy clerk,
Deputy CEO.
deputy CEO, sorry. And we certainly, it's nice to see you here.
Yes.
Part and listening in on the meetings. It's a concern, as you know, on some of our county roads, and we're doing severances, what has to be done and how, why it's being done.
Thank you for allowing me to participate. Look forward to it.
Sorry, Brian. In the beginning.
Through you, Mr. Chair, with respect to the training videos on November 24th, so those will be available as well. The orientation package that you were all given at that time, we'll go through that as well, just to go through all of the videos that you would previously seen, but we'll do them again, and then we'll also talk about anything else in the package and go through that orientation information, just as a refresher, if that.
The orientation binder that we got?
Yeah, the big one, exactly. So bring those with you as well, November 24th,
Okay.
again.
Maybe a reminder wouldn't hurt.
Sure. Go to that.
The day before. Mine is,
There's a lot in that.
Yes, there is a lot in that. And if need be, if it ends up being too long, we can always, half it, another half in December or something like that. But yes. And I guess since you guys will be here in the afternoon, we should look at lunch or ordering in something.
Right, just order, yeah. Sandwiches or something.
We should
To go out.
the note then for November 24th.
pizza and beer
I'm sorry? Beat Beat the party.
and the beer too, though. Oh, do you? 50.
I'm not sure if Ashley wants to speak at all. She might as well.
Yes.
We do have 6 minutes, so.
Thank
Go
you,
ahead.
Mr. Chair. This is not quite an item we have on the agenda, but I have put in my notice of resignation for this position, and I will not be joining you guys next month.
Aw,
We're sorry to hear that.
Oh, it's all good. Onward and upwards. Found an opportunity I couldn't say no to, so
Good.
gotta take them when you can.
just thank you guys for being such a good committee and so welcoming and making my job easy. It's been fantastic.
Best.
It's, you've been very supportive of the members and when we've asked you questions, I know myself, you've been very good at getting the answers to us. And we're gonna miss you, but you always look to the future. Wish you the best.
Thank you very much. I'm sure whoever comes in next will be just as good. But it'll be a perfect fit.
Break them in.
So there's,
Through you, Mr. Chair, it'll be me first, so. Yeah, after.
You're used to it.
there's no truth in the rumors that you're leaving because we've been such a burden on you.
So yeah, so that means I'll probably be taking over November, maybe December, depending on what occurs, so.
Yep.
So I'm back.
So there'll be advertising going out for a new position, to fill the position
We'll have
or?
to discuss it, yeah,
Yeah.
so. So let's see how that goes.
Any other surprises?
We do have a few deferrals on the overall on the agenda, so, but we also anticipate there will be a few people who want to attend to speak to certain applications. There's notably two that are deferred, have been asked to be deferred, but the people from the public will be attending, so we will need to conduct a public meeting on that and hear their comments as well.
Okay, yeah.
Okay, so, even if we ultimately, if you as a committee decide to defer, so,
Okay.
okay.
Those are ones, actually in E76 and down to E79. We do each one of those separate because I think a couple of them are different sizes, right?
I believe so, yes.
Do them each separately, okay.
Through you, Mr. Chair, we'll do them all separate just because the lots are slightly different
Yes,
sizes.
that's what I read, yes.
But through you, Mr. Chair, we can do them all as one big parcel, so you can maybe read them all out and then
Okay,
we can do one meeting for all four. Then you'll have to pass, for oceans.
Our time is set for, basically for one, so.
Yeah.
Exactly, yeah. We'd hope to, essentially they're together, but they're separate, so.
And all the conditions are the same for each one of them,
Yeah.
so.
Yeah.
it'll be a little-
but I'll just read the beginning of each one and then,
And then we can do one set of conditions and comments for all of them. But then, the committee will need to pass individual resolutions or motions on, yeah, so.
The committee passed a similar group of four on the other side of Plank Road from these four. And they've just started construction for putting buildings up, so people aren't waiting around to get the construction done.
No, it is a very hot time right now for building.
so I can't believe it. And Nancy knows there's another one ain't gonna come for our municipality subdivision.
Really?
I can't believe the land being sold and what they're paying for the land around the town.
Well, in Port Burwell, just down the street from me, an absolutely beautiful lot's being sold off. A stunning lot attached to an historic building. And it's $325,000
Just for the lot?
just for the lot.
Yeah, the lot,
So much.
lots behind me, like,
That's Port Burwell too, so.
they're over that.
Is that right?
They're over 3 and then the house they're looking to build is 900.
Jeez.
And they sold 3 houses last weekend, bang, bang, bang. They advertised them on Tuesday and they were sold Saturday.
Yeah, they don't last long in Port Burwell either.
Very, very busy time right now, so.
I think it's time now, it's, no, 9,
One more minute.
yes.
We have a minute. Can we discuss the menu for lunch next week?
Is there any allergies we need to know about, anyone?
Oh, what a good question. Not on my part anyway. I'm an omnivore, whether it's good for me or not.
Well, just send us an email for any allergies, if you do have them.
Yeah.
Just,
Okay,
okay, we'll now proceed with E5421. Take notice an application as made by Margaret Alice Goodhue 44912 Edgeware Line, St. Thomas, for consent pursuant to Section 53 of the Planning Act 1990 as amended to sever lands municipally known as 47148 Ron McNeil Line, Township of Malahide. And this is notice is a revised notice because it was deferred at a previous meeting.
Correct.
The applicants propose to sever a parcel with a frontage of 95.83 meters, 314.4 feet along the Ron McNeil line by a depth of 124 meters, 406.82 feet, and an area of 0.607 hectares, 1.5 acres, containing one residence, one frame barn, and one shed, surplus to the needs of the owners. The owners are retaining 43.16 hectares, 106.65 acres proposed to remain in agricultural use. Do we have any applicants or agents and interested parties who wish to speak to this application? Please introduce themselves to the committee.
You have Helen Button from Gunn and Associates. I'm the solicitor for the applicant. I don't have the applicant with me today, but she's reachable if we need her.
Thank you very much. I'll now ask Ashleen to proceed with the conditions.
Thank you, Mr. Chair. The Township of Malahide has reviewed this application and they have no objections to this severance, provided that the conditions they have included are met. The Conservation Authority, the Conservation Authority similarly has no concerns about this application, and County Engineering has reviewed this application and supports it subject to the provided conditions related to road widening and entrance permits. So as stated by our chair, we have seen this application before and it has come back as a revised application. So the originally proposed severed lot was just over 2 acres at 2.31 acres, so larger than typically permitted. And at the July 2021 Land Division Committee meeting, you guys opted to defer it to allow the applicants time to explore options on making this a smaller lot. The applicant has since come back and revised the severed lot, and it now has an area of 1.5 acres. And this reduction in lot size is supported by county planning staff. So this application for consent is consistent with both the 2020 provincial policy statement and complies with the county's official plan regarding surplus lot creation in agricultural areas. Planning staff recommend approval subject to the following conditions: that the owner dedicate lands along the frontage of the severed and retained lots/parcels up to 15 meters from the center line of construction of Ron McNeil Line, County Road 52, to the County of Elgin for the purposes of road widening if the right-of-way is not already to that width, to the satisfaction of the county engineer, all costs to be borne by the owner. That if necessary, an entrance permit be obtained from Elgin County for the entrance to the severed parcel, all costs associated with this shall be borne by the owner. A digital copy of the draft and final deposited reference plan be provided to the County of Elgin. Solicitor undertaking to provide a copy of registered deed for the severed parcel once completed. And municipal addressing to be provided to Elgin County from the local municipality prior to final approval to the satisfaction of Elgin County planning. Additionally, it is recommended that the following conditions from the Township of Malahide be included as conditions for this consent. That the applicant initiate and assume, if required, all engineering costs associated with the preparation of a revised assessment schedule in accordance with the Drainage Act as amended with the deposit to be paid in full to the township prior to the condition being deemed fulfilled. If the deposit does not cover the costs of the revised assessment schedule, the applicant will be billed for any additional costs incurred. That all outstanding work orders or bylaw enforcement issues be resolved to the satisfaction of the chief building official prior to the condition being deemed fulfilled. That the applicants initiate and assume all planning costs associated with the required official plan amendment, zoning amendment, minor variance, or other land use planning process as required in accordance with the Ontario Planning Act, with such cost to be paid in full to the township, and that the required processes be successfully completed prior to this condition being deemed fulfilled. Confirmation that private sewage system can be confined entirely within the boundaries of the newly created parcel. That system be in conformance with all required setbacks from lot lines prior to the condition being deemed fulfilled. That the necessary deeds, transfers, and charges for certificates and/or instruments necessary for registration be submitted in triplicate prior to the certification, all of which are to be fully executed. That all applicable property taxes, municipal fees, and charges be paid to the municipality prior to the stamping of deeds. That an electronic version of the reference plan be submitted to the satisfaction of the municipality. And finally, that the applicant is responsible to apply and pay all fees to the township with respect to civic addressing numbers / signage for the severed and retained portions of the property prior to the condition being deemed fulfilled.
And just one thing I should have asked me at the beginning of the meeting, were the signs in place for all your? And I know these were and mine were too, so sorry about that, Ashley. Any other questions of any of the members for, on this application? Yes, John?
Through you, Mr. Chair, to the individual who's representing, I'm sorry,
Helen Button.
Ellen Button.
Button.
the reduction is substantial. It was one of our concerns. How did you decide on, if you want me asking, on the reduction, which is equivalent in area of around 35%, which is considerable?
The applicant spoke with the surveyor, and I mean, she wasn't, I mean, we kind of listened to the comments of committee members of the last meeting. You know, bringing it in at all would have had to bring it into that treat area. A lot of the comments were mentioning a 1.5 acre size for the severed lot. And so just in conversation with the surveyor, they arrived at that new size.
Thank you.
Yes, any other members have anything, questions?
I'll move the recommendation.
I'll second it.
Moved by Dennis O'Grady, seconded by Jack Van Castren. All in favor? Carried. Thank you very much, Mrs. Button.
Thank you.
Through you, Mr. Chair, you'll need to read that.
Yes, I'm just going to do that now, yes. The decision rendered today for this application will be circulated within 15 days after the notice. There is a 20-day appeal period from the giving of the notice of decision in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of the notice, provisional consent becomes final. The applicant has 1 year to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Ashleen Laverty at laverty@algon.ca. A copy of the comment package is also available upon request and includes all correspondence received. Thank you. It's now,
29.
yes, thank you.
1 minute. We're just, someone's here for one of the applications, so we're just dealing with that.
Okay. We'll now deal with E71-21. Take notice that an application has been made by Barbara Farms Incorporated, 33812 Fingal Line, Fingal, Ontario, for a consent pursuant to Section 53 of the Planning Act 1990, as amended, to sever lands municipally known as 11714 Coyne Road, Municipality of Dutton. The applicants propose to sever a parcel with a frontage of 64 meters, 209.974 feet along Coyne Road by a depth of 106 meters, 347.769 feet, on an area of 0.68 hectares, 1.68 acres, containing one residence and one small drive shed, surplus to the needs of the purchasing farmer. The applicants are retaining 40 hectares, 98.84 acres proposed to remain in agricultural use. Applicants or agents wishing to speak to this application, please introduce themselves to the committee.
Herman Lansing.
Thank you, Mr. Lansing. I'll now ask Ashleen.
The package.
Thank you,
There.
Mr. Chair. The acceptance of applications E71 and E7221 occurred prior to legal interpretation being provided to the Land Division Committee regarding consent applications, specifically related to surplus farm dwellings. Shortly after this interpretation was provided, and prior to any discussion taking place, the Council of Dunwich recommended approval of both of these applications. The owner on the application form is listed as Barber Farms, and that is actually not the correct owner as per municipal records. As such, the current owner cannot demonstrate how they meet surplus farm dwelling criteria contained within the county official plan and the provincial policy statement. And due to both the acceptance of this application at the county level and the recommended approval at the municipal level from Dutton Dunwich, the planning department recommends either deferral of these applications until such time as the applications are corrected to meet county and provincial policy statement policy related to surplus farm dwellings, or refusal.
Any comments from any members? Would you like to comment, Mr.?
Yes, the application was put in. This is the 5th application before your committee here that's been done in the same manner. And I understand that there's been some changes made, but we had already given our application, it was accepted. I went through the details with Ashley to make sure that all the paperwork was proper. She told me it was, and then things change. I don't know if that's quite fair to the application or not. If we would have been told up front 4 months or 5 months ago, we would have probably not put in the application until things were the way that you're now asking it to be. But to me, it's something happened in between that we don't know about. So that's one thing. Barber Farms has been renting this land for many years. And the Hooters are now in a very unhealthy position, and that's why they wanted to sell. So of course, we just want to continue farming the land. So that's where we are.
Nancy, do you have a comment?
I don't, other than at the time that the application was made, it was around the time of our discussion with legal, so I think the application was accepted under different circumstances, which obviously have now changed, and we have clarified and changed our application forms accordingly because of that. So the information we have before you is that the applicant does not actually own the land, sorry, the owner of the lands, the application lists Barbara Farms as the owner of the subject lands, but Barbara Farms are not the actual owners, so we have spoken to this gentleman several times with respect to that. So, and he has indicated that he can finalize the sale in order to have that corrected, and then we can defer the application if need be until such time as that occurs and continue on with the application once that's been corrected.
Any comments from any members? John Selden?
Yes, through you. Sir, you said you've put in 5 applications before this one?
We, not on this particular. I've been before you, this is the 5th time in the last number of years, 4 Barber Farms in each case.
And were you the owner in each case?
Never. we always threw a conditional offer, subject to getting severance, and then we would close. We always have.
I don't, and I'm not questioning your integrity, but the application clearly indicates that Barbara Farms are the owner, and in fact, they weren't. Was there some reason that you went that route?
That's the way it was always accepted. I just did what the county asked at that time. And then it's just now changed that you can no longer do it through an agreement to purchase with the condition of severance. That's what's changed.
Were your previous applications under the same circumstances?
Yes.
See, I think, John, you remember we had a meeting with the county lawyer a
Yes.
while ago, and we had to straighten up some of this areas. So that's why,
We've always done what was asked of us in the past. Like, we're just interested in buying farmland, as you know, from our previous. And now we got caught here. And I understand, there's been a few municipalities that have been caught. And it just, we should have been told up front that you can't do it this way anymore, and then we would have probably made some changes. But the application was accepted, the signs were posted, the money was accepted. We just think we're caught in the middle.
yeah, I understand that, but I understand, you have to understand that we had to straighten it up, and most municipalities know that we have the new, on the application, what's on the application. Dennis, you have a question?
Yeah. Question. So there's a willing seller and purchaser. That's not an issue.
I have that here, somebody should know.
All right. So that's not an issue then. Just on a technical point of view, staff, I'm looking at this and the next application. So are two severances, are they allowed on a farm consolidation?
Sorry, through you, Mr. Chair, what do you mean?
On this application,
There's two severances, there's the house that's
so
built.
E71 and E72. So we're being asked to look at both severances as part of farm consolidation. That's allowed under the Planning Act?
Through you, Mr. Chair, yes, it would be allowed through the policies of it would be farm consolidation.
Yeah,
So we understand your frustration with the bureaucratic process. We get involved with that as well. So, but since you have a willing seller and purchaser, and staff have already said that deferral with waiving a fee is appropriate, then I think that that's the resolution that I would like to put on the table, that you make the application for both of those severances comply and allow the owner to make the request for the severances as farm consolidation, and then we would waive the fee for that when the owner comes in. That makes sense.
I don't think the owner qualifies for a severance because he's not a farmer.
Yeah, through you, Mr. Chair, what would need to happen is,
that's right.
he would need to purchase these fully because he is ultimately severing off what would be surplus to his farming needs. So he would need to be the owner and applicant.
Yeah.
But the present owner only owns that one farm,
He wouldn't qualify.
doesn't qualify.
That's right.
Same as the one we discussed at the last meeting, we had one discussed that it didn't qualify and it was deferred.
I understand the committee is interested in doing the severance. That's not the issue. It's our timeline and so on. My question then is, if we defer it, and should we, and I would think we can close quickly, but then the existing owners, they're the ones taking the risk, and that's where I don't know if they're willing to do that risk. Because of course, we sever, and then we gotta transfer the land back, these two homes back to them. And I'm sure you can do that legally with $1 fee or something. But should the severance not go through at that time for another reason, which I don't know at this time, then the existing owners would have the great big problem. And that would, we wouldn't feel right with doing that, so I know that's sort of the catch-22 that we're in.
Can you not, and I'm just asking this through to Nancy too, most places now are putting an understanding in them when the farm is sold, that for a dollar or whatever it is, the houses, they get the severed property. And we had that on one past one, right?
Through you, Mr. Chair, usually it's a side agreement that gets done.
Size,
That says
Yeah.
upon finalization of,
organization, yes.
so.
Any further questions of the members? We have a motion on the floor. Do we have a seconder? Seconded by Rosemary. That it be deferred. The applications E7121 and E7221 be deferred. Any other questions?
Chairman, procedure, can we do both of those in one resolution?
Through you, Mr. Chair, they are deferrals, so we can, there's no need to, for instance, the chair doesn't need to go through that statement or anything like that, so we can do them as one.
Or Jack?
Through you, Mr. Chair, did the motion include deferral with no further fees?
Yes.
Yes, it did.
Okay.
All in favor? Carried.
So we're deferred till,
You're deferred until you can demonstrate that you have purchased the property fully.
so no time limit.
There's no time limit on that, no.
Could I ask, and somebody's in charge, should we be able to do it within a month? And are we on the following month on this? And really, there's nothing else changes then it's just whether or not it's approved or not. Is that correct?
Yep, through you, Mr. Chair, we have deadlines in terms of our agenda and when it needs to be deferred. So if you could contact Ashleen within the next few days and she can tell you what the deadline would be to submit based on next month.
For next month's meeting.
We host, Ashley? Like that's sort of the time thing, isn't it?
It's the circulation.
Yeah. Is it all redone again?
Yeah, I guess that's the question. The applicant would be you, so that's changed. So yes, we would need to recirculate that. So if that's the case, we would,
Probably take 2 months.
yeah, it'll take how, 8 weeks, I believe, is the deadline typically. So, yeah,
That's what Ashley said.
yeah. So it'll be that. We will need to do recirculation based on a new applicant.
Okay,
Okay, thank you very much.
thank you very much. An understanding.
Mr. Chairman, just, Nancy, because our December meeting is a little bit sooner, if he was hoping to get it in December, we should let him know what the deadline is for a December submission,
Absolutely.
since it's a little bit
Gonna
sooner.
be-
Mr. Chair, it's, I believe November 2nd. I don't think he'll be able to meet that. But we can talk further about it with, between Nancy and I and the applicant. See if we can still meet our deadlines and get it done.
Yeah, exactly.
See,
Plenty of time to get things.
Yeah, we just need to ensure that we have enough time for circulation. So hopefully we can, give them a little bit of a revised deadline noting the issues.
Under these circumstances,
Exactly.
yes,
special circumstances. Well, I think it's through, Mr. Chair.
yes, Jack.
I feel for the guy. It's unfortunate that he's caught in this time. It's timing. And I understand his position. However, that's why we brought in legal counsel to discuss, because there was too many of these coming in where stated application for consent, name of owner.
Yeah,
That's incorrect.
that's right.
We had to deal with it.
Yes,
I think we have to stick with that
yes, we do.
forward.
I strongly believe that too. We have to have the proper.
That's why I asked earlier about confirmation of who the owner is legally on the deed. That is an important feature when we get an application in, that is confirmed.
Through you, Mr. Chair, that's now a requirement of applications moving forward, is there has to be some proof of ownership
Yeah.
provided.
Great,
Yes, and it's got to be that way.
appreciate that.
We've got a few minutes before the next application.
Chairman, while we've got a minute, we want the minutes to reflect that the signs are all up. We don't have all the members here, I know. But we normally have that in the minutes.
Yes, I did ask that, and the other thing that I've asked is my one application that we just dealt with. They just have a post in the middle of the lot with a sign on each side. You can drive it down, you can see it, but it must be on each corner. And I told the present people living in it that are the owners that they had to move them to the edge of the property. It can't be just in the middle by the side of the laneway. And you drive one way, you see it, and you drive the other way, you see the other one. They're sideways.
So is that, would the protocol be that if I run into that I would knock on their door and tell them that that's the case? Or
I happened to see is the lady in the laneway getting her mail. She asked me what I was doing. Well, I was taking pictures. I take pictures of all my signs on the property area. And I said, this isn't. And as of yesterday, they're not fixed yet. But I think they knew that there was some.
Through you, Mr. Chair, typically if you know if there's an issue, let us know as soon as possible and we can contact the applicant to let them know that they need to be
I just happened to
installed appropriately before the deadline.
ask me and I took it upon myself just to say
Yeah.
that.
I think I would too if I was asked what I was doing. However, is this an issue legality if they don't? Of yesterday, it wasn't.
Well, through you, Mr. Chair, we're supposed to give notice 14 days before the meeting, so it has to be done 14 days prior to the meeting. So if they, and in fact, that did come up a few months ago where there was signs that had not been installed properly and we ended up deferring the application until that had got done. Yeah, exactly, so.
But I think I'm the only one or two on that road besides them.
Right.
And through you, Mr. Chair, as well, just a reminder, if you do encounter applicants, for instance, while doing your site visits, you're really not to be discussing the application or anything like that with anyone. Obviously, you're supposed to stay impartial, so really just to review the site and ensure the signs are installed correctly.
I just find it very easy. I just take a picture of each sign.
Yeah.
Because in the wintertime, they're there, then they're not there. If they're too close to the road, the snowplow knocks it down,
Oh, yeah.
especially on a gravel road and there's not much ditch. Okay for the next one?
Not quite yet, 2 more minutes.
Sure, it's Dogger's place. The old one's because he had the shop going that way.
I think just mentioning it, I think we knew this could be a concern when we had our lawyer speak to us. About this getting all this changed over.
But it had to be done.
See, I think too is, they know what the new houses would cost them if they moved to town, so they want their houses on the farm.
Right.
Through you, Mr. Chair, from, it's come up several times is that I guess, what was permitted before was the agreement of purchase and sale for these types of applications. And I guess that's the biggest distinction, is that's no longer considered to be because they are not the owners, which under
Yes, that's right,
is really what's required.
that's right.
You have to be able to demonstrate that you as the owner, this is surplus to your needs, the surplus farm dwelling, so. And if that can't be demonstrated that you're the actual owner of that property, then you're not meeting the policy.
That's right.
Oh, through you, Mr. Chair, one thing that I also wanted to just bring to your attention is we need to do a year-end report with respect to the Land Division Committee. So that's something that we'll need to draft, and hopefully we can bring a draft to the November meeting.
Yes.
We can review it, and then I believe typically you're invited to the council meeting to, if you'd like, give a presentation or go through the report if you'd like, or alternatively, I think I can do it as well, so we can discuss that.
Yeah.
Okay. It is 9:50.
Okay, 9:50. An application E73-21. Take notice that an application is made by Anna and Isaac Giesbrecht, 49485 Nova Scotia Line, Aylmer, Ontario, for consent pursuant to section 53 of the Planning Act, as amended to sever lands municipally known as 149485 Nova Scotia Line, Township of Malahide. The applicants propose to sever a parcel with a frontage of 37.717 meters, 123.68 feet along Nova Scotia Line by a depth of 68.575 meters, 224.98 feet, and an area of 0.26 hectares, 0.64 acres for future residential use, conversion of the barn into a dwelling. The applicants are retaining a parcel with a frontage of 32.465 meters, 106.51 feet along Nova Scotia Line by a depth of 68.58 meters, 215.15 feet, and an area of 0.22 hectares, 0.54 acres, proposed to remain in residential use. Do we have any applicants or agents and interested parties who wish to speak to this application? Please introduce themselves to the committee.
Yes, good morning. Dave Rowe, the agent for the applicant. I'm online. Thank you.
Thank you, David. I'll now ask Ashleen. Proceed.
Through you, the Township of Malahide has reviewed this application and they have no objections subject to the provided conditions. The Conservation Authority did not provide any comments on this application. County Engineering supports the application subject to the provided conditions related to road widening, direct connection to a legal outlet, lot grading, and entrance permits. This application for consent is consistent with both the 2020 provincial policy statement and complies with the County of Elgin official plan regarding lot creation in settlement areas. If approved, planning staff recommend the following conditions be included as conditions for consent. That the owner dedicate lands along the frontage of the severed and retained lots / parcels up to 15 meters from the center line of construction of Nova Scotia Line, County Road 42, the County of Elgin for the purposes of road widening if the right of way is not already to that width, to the satisfaction of the county engineer, all costs to be borne by the owner. Direct connection to a legal outlet for the severed and retained lots is required if an existing connection is unavailable, to the satisfaction of the county engineer. All costs to be borne by the owner. Discharge of water to the county road allowance is prohibited. That if necessary, an entrance permit be obtained from Elgin County for the entrance to the severed parcel. All costs associated with this shall be borne by the owner. Lot grading plan is required for both the severed and retained lots. Municipal addressing to be provided to Elgin County from the local municipality prior to final approval to the satisfaction of Elgin County Planning. Digital copy of the draft and final deposited reference plan be provided to the County of Elgin. Solicitor undertaking to provide a copy of registered deed for the severed parcel once completed. The applicant shall provide to the Land Division Committee a signed acknowledgement and undertaking confirming A, that the applicant has been advised that the Ontario Building Code Act requires confirmation of servicing, including the individual on-site potable water supply and or individual on-site sewage system prior to the issuance of a building permit. B, that the applicant has made the necessary inquiries of the municipality to determine the work necessary in order to confirm that the site conditions are suitable for the long-term provision of such services with no negative impact. And C, that the applicant undertakes to advise any future purchaser of the above acknowledgement and the results of such inquiries. That condition is just dealing with development on partial servicing. Additionally, it is recommended that the following conditions from the township of Malahide be included as conditions of consent. That the applicant initiate and assume, if required, all engineering costs associated with the preparation of a revised assessment schedule in accordance with the Drainage Act as amended, with the deposit to be paid in full to the township prior to the condition being deemed fulfilled. If the deposit does not cover the costs of the revised assessment schedule, the applicant will be billed for any additional costs incurred. That the applicant initiate and assume, if required, all engineering and construction costs associated with construction of a new municipal drain and or relocation of municipal drain to be commenced in accordance with the Drainage Act. All costs to be paid in full to the township prior to the condition being deemed fulfilled. If a lot rating plan is required as a condition of severance, it should be done in conjunction with the new municipal drain or relocation of said municipal drain. That the applicant be required to retain the services of a professional designer and an engineered lot grading development plan and ditch grading plan prepared in accordance with good engineering practices that are suitable to the township prior to the condition being deemed fulfilled. That all outstanding work orders or by law enforcement issues be resolved to the satisfaction of the chief building official prior to the condition being deemed fulfilled, including that the township be satisfied that all accessory structures are located and situated in accordance with applicable zoning bylaws. That the existing asphalt driveway which crosses over the proposed new lot line be removed and returned to sod. That the applicants initiate and assume the full cost associated with the required development agreement with the Township of Malahide in accordance with section 53 of the Planning Act to ensure the conversion of the existing barn to residence occurs in accordance with the Ontario Building Code and within a specified period of time. Confirmation that private sewage system be confined entirely within the boundaries of the newly created parcel. That system be in conformance with all required setbacks from lot lines prior to the condition being deemed fulfilled. The owner has the necessary review and lot assessment conducted to ensure that it is suitable for the installation of a sewage disposal system and payment of necessary fees per lot. That all applicable property taxes, municipal fees, charges be paid to the municipality prior to the stamping of the deeds. An electronic version of the reference plan be submitted to the satisfaction of the municipality. And finally, that the applicant is responsible to apply and pay all fees to the township with respect to civic addressing numbers and signage for the severed and retained portions of the properties prior to the condition being deemed fulfilled.
Any questions of any of the members? John Selden?
Through you, Mr. Chair, I understand the severed parcel, there's going to be the barn conversion, but there are two sheds also on there, I believe. Are they to be removed or are they staying in place? To David Rowe, I guess, Dave?
Yeah, my understanding, well, any sheds that are there would have to conform with the zoning bylaws, so they may either be removed or at the very least, they would have to be moved to comply with the zoning bylaw. And being as we're doing an agreement with Malahide, and that'll be picked up as part of that, I would assume.
Okay, and may I ask one other quick
Yes.
follow-up question?
Go ahead.
Also, what's the issue with the asphalt driveway? Is it just felt that it won't be needed by the one lot and therefore it's being taken up and put back to sod? It would be a shame to take it up, put it back to sod and then put another driveway in place.
It goes across the line.
Across the lot line.
Even though it goes across up, but maybe the other.
Oh, is that a condition, David, of the municipality?
Yep.
Through you, Mr. Chair, yes, it's a condition. And
It is a condition of the municipality.
the municipality asked for that the existing asphalt laneway which crosses over the proposed new lot line be removed and returned to sod, so.
Yep.
I think you're on mute, Dave.
He's talking about.
Yeah, but it's a condition of the municipality is written in here.
But why is it a condition?
It's the same in our municipality. You can't have your laneway on a piece, even if it's a severed. We've had it. You can't have that.
Even if that portion that's on the severed lot can be of use to the severed lot owner? Really?
One of their conditions.
Not a beautiful laneway, John. It's angled.
Yes.
And the severed comes here, so there wouldn't be a use for a little triangle pavement.
Okay, I was thinking, all right.
It's not the whole thing.
Yes, Jack?
Mr. Chair, just a point of clarification on the original application notice. There is an error. There's a 1 in front of the address, 49485 has a 1 in front of it. So that should probably be noted. Legalities. Second, like it says Anna and Isaac Giesbrecht of 49485 Nova Scotia to sever lands known as 149485. So just point of clarification there.
I tried to look for that and didn't find it.
You won't find that one.
No, not down there.
So noted then. Any other questions?
Just a quick comment through you, Mr. Chair. For some reason, Malahide is copying Rosemary and I on their correspondence. Is there some reason for that?
Through you, Mr. Chair, I don't know. I can understand Rosemary, her being the
I can't understand.
committee member, but I'm not sure why.
I don't understand that.
I'll clarify with them why.
I
Yeah, of course.
feel special.
Tell me that they sent it to the chair and I'm going, well, they don't pay attention to who the chair is.
Yeah.
What
All right, thanks.
Clarify with them.
Allison's doing.
Jack?
Excuse me, I'll make the motion that this be approved, subject to all the conditions that are noted. Several.
Second.
Moved by Jack Van Castren, second by Rosemary Kennedy.
I have a quick question.
Yes,
I'm in favor of everything here. I just have a technical question. They're gonna put together a development agreement to ensure it does get converted into a residential.
Yes.
So our consent application, our consent approval expires after 1 year, correct? Can their development agreement extend beyond that year? So as long as they've got it in place before the end of the year, it satisfies our conditions and we can approve severance. And they could have 2 years, 3 years, 5 years, whatever they want on their development agreement?
Yeah, through you, Mr. Chair, the development agreement doesn't have necessarily, usually what happens is they'll take securities or something to ensure that any of the conditions within the development agreement are met.
Okay.
And sometimes they'll put dates in there as well, but yeah.
Good question.
all in favor? Carried. The decision rendered today for this application will be circulated within 15 days after the notice. There is a 20-day appeal period from the giving of the notice of decision in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of the notice, the provisional consent becomes final. The applicant has 1 year to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Ashleen Laverty at alaverty@algon.ca. Copy of the comment package is also available upon request and includes all correspondence received. Thank you.
Through you, Mr. Chair, we're just trying to see if there's some people here in attendance for the next item, so if you can just give us a minute.
Yeah, Dave Farrell, I'm available for this would be the Carroll applications, which I understand are going to be deferred.
Thank you, David. Yes, they will be, but there may still be people here because the
Yeah.
notice went out, so we'll need to.
Yes, and we're just ahead a bit. It's not due till 10 or
Oh.
10 o'clock.
Actually, early.
Oh, we're all right.
I thought we were behind.
Okay. Application, is Don out checking?
Don has, yeah, gone out.
Speaking with somebody.
How did you have Thanksgiving with your family?
Thank you for asking. I had a great,
No, she's the one that put the note.
really well. We had modest
Never
family get together,
Heard of Darlings, but not Spruce.
just relaxed and had a great time. How about you? That's
So now we'll deal with application E74-21. And it's to Canada Southern Railway grounds. And we will take notice an application has been made by 181711 Ontario Incorporated, B&S Carroll, 49934 Glencolin Line, Aylmer. Consent pursuant to section 53 of the Planning Act as amended to sever lands municipally known as the Canadian Southern Railway grounds, Township of Malahide. The applicants propose to sever a parcel with a width of 2.592 meters, 8.5 feet, by a depth of 63.316 meters, 207.316 feet, and an area of 0.098 hectares, 0.04 acres for future residential use to be conveyed to lots 46, 47, 48, 49 Courtright Ave as seen on the provided plan. The applicants are retaining a parcel with an area of 3.326 hectares, 8.22 acres for future residential use. To applicants or agents and interested parties who wish to speak to this application, please introduce themselves to the committee.
Yes, Dave Rowe, agent for the applicant. Yeah, I'm here if there's any questions.
Yes, go ahead.
Is it okay to take the mask off?
Yes.
Thank you, that's much easier. Good morning. I'm a resident of Springfield, and I just want to say off the top that this whole planning severance world is new to me. I don't really know too much about it. I was one of the people that did get a letter notifying about these two applications. I understand that there may be deferrals in place in relation to them, but I still want to take this opportunity.
Could you please introduce yourself?
I'm sorry, my name is Kimberly Darling.
Yes, and okay, we are going to hear first from Ashleen,
Okay.
and we'll ask for your comments.
All right.
Thank you.
Thank you, Mr. Chair. So the agent on this application being David Rowe has requested deferral of application E7421, just to provide some additional clarification for adjoining landowners prior to proceeding. Any revisions may require recirculation of this application, however. But because we did circulate and members of the public are aware of this, we did receive a little bit of correspondence from residents of the area, one of those being Kimberly Darling, who is in attendance, and I will let her do her comments. And we also received some comments from Bill McIntyre, who inquired as to the purpose of the proposed severances, as well as some traffic and connectivity considerations related to connecting the amenities of the north to the south side of these lands. So, Mr. Chair, if you're all right with Kimberly providing her comments,
Yes,
and
I'll have-
summarizing.
Go ahead, Kimberly.
Thank you. So I'm not really sure, as I said, of these processes here, but I thought I would take this opportunity for a few minutes. I know you have schedule, and so I just want to take a couple minutes to talk about some things, even recognizing that there's a deferral in relation to both of these applications from two different parties. So my concern, it's a very small village, so the parcel of land that they're looking at, there is no access from a road currently. And so, you know, what does that, my understanding is that if this goes forward, then there could be other things that follow. And so how does that impact vehicle traffic and vehicle movements, particularly for the area that is zoned industrial? The industrial zoning really falls from the fact that it's railway lands, and so that's standard for that to be industrial. And I understand at one time, many years ago, there was actually a station there, which is no longer there, so there are station grounds. So the the whole area around, that is like a pocket of industrial, and I know this isn't a zoning meeting, but there's a pocket of industrial area that could be industrial, which is essentially in the middle of the village of Springfield. And so I think that would ultimately affect the enjoyment of the residents there, not to mention an increase in noise and traffic and pollution if that area became populated. There's children that walk to school, and so how does that impact the traffic flow? I have concerns about the water access. We're on wells in Springfield, so if there's industry that goes in there and occupies those spaces, will that have an impact? I don't have answers to these questions. What are the other environmental impacts? There is a drain there called the Simpson Drain. And so, you know, how would the grade of the land, if that were to be amended somehow, how is that gonna affect it? Where my property is, where the railway's at the back, and there's a huge steep bank. And so that is technically was railway property, it's now owned by these other folks. You know, is there remediation of the land required, and how do we know that that's going to happen? There's a wonderful heritage, I call it a heritage because it was built in 1890 railway bridge there. Now that particular bridge happens to be, there's a strip of municipally owned property which actually divides up these parcels, this overall parcels of land as well. So I'm not really sure what the plan is there. And I can tell you that the space right now is enjoyed tremendously by all of the people in Springfield, you know, whether walking, biking, there's ATVs, and I know technically probably they're not supposed to be on that property doing that, but nonetheless they do. But I just want to circle back. So my biggest concern is that we have this pocket of industrial. There's no access to it by road whatsoever, and you know the impacts of that going forward. So that is my comments. Thank you so much for your time today.
Thank you very much for your comments. Any comments from the members of the committee? Jack?
I guess a point of clarification through you, Mr. Chair. Kimberly, I'm not understanding what you're meaning about there's no access from a road. It goes clearly right to Springfield Road, where the railway crossed Springfield
I
Road.
don't think it would be wide enough because there's banks on either side of, like the railway's kind of built up.
Okay, but we're just talking about the property and there is road access. Hills can be excavated down and whatever. It's clearly going right to Springfield Road on the overhead.
Yes, the property goes to Springfield Road, and my concern is that I'm not sure that it would be, if there would be space enough there for a road to go through. Given the grades of the land, it's quite steep on one part of the bank. And then if you impact the grade of the land, then that's gonna impact the Simpson Drain, which has already been overflowing tremendously over the past 8 weeks. It's at its maximum.
Fair enough. My only comment would be that since the agent has already requested deferral of the application, it'll likely be deferred, no problem, no issue. But I would think, my personal opinion, that most of your concerns could be dealt with at the Township of Malahide. And then this deferred application will be dealt with there before it comes back to us.
Right.
My only other comment, being from the area, this first application, E7421, was strictly for 8 feet of land to be added to the backyards of existing lots, which technically I wouldn't see a problem with. But again, it's been requested to be deferred, so that's how I'll be voting.
Any further questions? John?
Just as a follow-up to that, is your objection or your, to the 27421 or to 7422, one or the other or both?
Through the chair, my objection is more strongly to E75, because of the
Sorry.
industrial nature of it. But
521.
of course, some of the comments that I make also apply to E74. So it's kind of both.
Yeah.
And I just want to say that I'm not opposed to development. I mean, it would be wonderful to see some growth happening in these villages. Most of the people that live there work elsewhere. So it'd be great to have an opportunity for that to occur, but to have it in the middle of the largest residential area of the village doesn't really make sense. So that's what.
Thank you for your comments. Any other comments from members?
I just wanted to ensure that you understand, and Jack said it, but that you understand that the majority of the conversations will happen at the local level, and then it gets submitted to us. So it is very much that dialogue you've got to have with council, other landowners, the proponent, the agents, all that, to try and resolve all your concerns and come to a compromise. So we don't want you to go away thinking that we are, doing all of that.
Through the chair, I appreciate that clarification tremendously, and I'm learning a lot about this process as I go. My work history was in budgets for a municipality for over 37 years, so I'm very familiar with that end of things, but this is all new, so I appreciate that, and I understand that the Township of Malahide, I'll make sure that my concerns are communicated to them as well, so that they're aware. And I'm sure that we can work it out and make it a win.
Thank you very much for your comments. And yes, I know the municipality will be, I can see that they're going to be dealing with this now.
Motion to defer.
Moved by Dennis to defer.
Is this for just 74 or for both?
For both.
This is for both these. So this will be a deferral of E 7421 and E 7521. Is that right, Dennis?
Yes, correct.
Motion is seconded by John Selden.
You got a question, Dan?
I have just a quick comment through you, Mr. Chair. With respect to some of the comments that have been made from the agent as well, it should be noted that there may need to be fees charged because there may need to be amendments to these applications depending on if the parcel needs to be severed.
That's right.
There needs to be additional applications, for instance. That should be noted as well.
Because there is a number of other people, as we've seen, and I've heard there's other people that are going to want to speak about it. So I agree with that it's.
The motion is to defer and will allow staff to make a decision what applies in respect to if it's a substantial change or requires a new fee.
Yeah, it should be. Okay. Any other questions? Any other comments on the motion? All in favor? Carried.
So now I know. It's that house right there. I think it's. Is it cause it's.
These back.
In here, belong in here.
There.
Did you get out there and walk? You
Seen her around town.
No, well, they're right along Plain. But they had their signs up in good time.
signs for you.
Just going to the right.
We're just
And I think she
the
said,
space and then boom, boom,
seen the. The track,
stop on Plank Line.
Bob's. Excavators up and down there.
Okay, the next one is application E 76-21. Take notice an application has been made by Greg Mitchell and Scott Gilvasey, 13 Rideout Street, West Tilsonburg, for consent pursuant to section 53 of the Planning Act as amended to sever lands municipally known as Plank Road, Municipality of Bayham. The applicants propose to sever a parcel with a frontage of 26.33 meters, 86.38 feet by a depth of 40.59 meters, 133.16 feet, and an area of 0.1 hectares, 0.25 acres for future residential use. The applicants are retaining a parcel with an area of 4.18 hectares, 10.34 acres to remain in agricultural lands. Now I'll read each one of them. We have application E 77-21. Take notice an application has been made by Greg Mitchell and Scott Gilvasey, 13 Rideout Street West, Tillsonburg, for consent pursuant to section 53 of the Planning Act as amended to sever lands municipally known as Plank Road, municipality of Bayham. The applicants propose to sever a parcel with a frontage of 22.00 meters, 72.17 feet, by a depth of 42.05 meters, 137.96 feet, an area of 0.09 hectares, 0.22 acres for future residential use. The applicants are retaining a parcel with an area of 4.09 hectares, 10.12 acres to remain in agricultural lands. Application number E 79-21. Take notice an application has been made by Greg Mitchell and Scott Gilvasey, 13 Rideout Street West, Tillsonburg, Ontario, for consent pursuant to section 53 of the Planning Act as amended to sever lands municipally known as Plank Road, municipality of Bayham. The applicants propose to sever a parcel with a frontage of 21.5 meters, 69.06 feet, by a depth of 42.00 meters, 137.78 feet, and an area of 0.09 hectares, 0.22 acres, for future residential use. The applicants are retaining a parcel with an area of 3.91 hectares, 9.66 acres to remain in agricultural lands. Excuse me here, I lost one too fast.
Easy to do.
Take notice an applicant, this is E 79-21. Take notice an application was made by Greg Mitchell and Scott Gilvasey, 13 Rideout Street West, Tillsonburg, for consent pursuant to section 53 of the Planning Act as amended to sever lands municipally known as Plank Road, municipality of Bayham. The applicants propose to sever a parcel with a frontage of 21.50 meters, 69.06 feet, by a depth of 42.00 meters, 137.78 feet, and an area of 0.09 hectares, 0.22 acres for future residential use. The applicants are retaining a parcel with an area of 3.19 acres, 9.66 acres to remain in agricultural use. So that's,
Did you cover all four of those? 77, 78, 79?
I'm at, yeah.
Yeah. Okay.
Yes. Any applicants or agents and interested parties who wish to speak to this application, please introduce themselves to the committee.
Good morning, it's Andrew Galazzi here from CJDL Consulting Engineers as the agent for the applicant.
Okay, thank you very much. I'll now ask Ashleen to proceed with the conditions.
Thank you, Mr. Chair. So just to clarify, these are 4 separate applications. Mr. Chair would have read them all, and introduced all of them, but because all of the comments received from all of our different agencies and departments relate to all 4 of the applications, we've opted to just go through all of those conditions and comments as one group instead of reading the same conditions and comments 4 times in a row. So we'll have to vote on these separately after. So the municipality of BAM recommends approval of these applications subject to the conditions they have provided. County engineering has no objections to these applications, provided the conditions regarding connection to a legal outlet, a potential entrance permit, and lot grading are satisfied. And the Conservation Authority provided no comments. So these applications for consent are consistent with both the 2020 provincial policy statement and the County of Elgin official plan regarding lot creation within settlement areas. As such, planning staff is of the recommendation that the applications are acceptable from a planning perspective and recommend approval subject to the following conditions. A digital copy of the draft and final deposited reference plan be provided to the County of Elgin. Solicitor undertaking to provide a copy of registered deed for the severed parcel once completed. Municipal addressing to be provided to Elgin County from the local municipality prior to final approval to the satisfaction of Elgin County planning. Direct connection to a legal outlet for the severed lot is required. If an existing connection is unavailable to the satisfaction of the county engineer. All costs to be borne by the owner. Discharge of water to the county road allowance is prohibited. That if necessary, an entrance permit be obtained from Elgin County for the entrance to the severed parcel. All costs associated with this shall be borne by the owner. A lot grading plan is required for the severed lot. And the applicant shall provide to the Land Division Committee a signed acknowledgement and undertaking confirming A, that the applicant has been advised that the Ontario Building Code Act requires confirmation of servicing, including an individual on-site potable water supply and or individual on-site sewage system prior to the issuance of a building permit. B, that the applicant has made the necessary inquiries to the municipality to determine the work necessary in order to confirm that the site conditions are suitable for the long-term provision of such services with no negative impact. And C, that the applicant undertakes to advise any further purchaser of the above acknowledgement and the results of such inquiries. So that condition again just deals with development on partial servicing. Additionally, it is recommended that the following conditions from the municipality of BAM be included as conditions for consent. Installation of individual private wells with water quantity and water quality reports for bacteria and nitrates content meeting the provincial standards for residential use as a matter of public health and safety. Installation of municipal sanitary sewer connection to each of the severed lots at the applicant's cost for permits and installation. Engineer designed overall lot grading and lot drainage / drainage plan showing direct connection to the existing municipal drain, showing lots will not have a negative drainage impact on abutting lots. Rezoning of the severed lands to remove the H2 holding zone by entering into a subdivision agreement with the municipality for servicing and adequate recognition that a plan of subdivision for the retained lands is not assumed. Digital copy of the registered plan of survey. Cash in lieu of parkland dedication fee for each of the 4 created lots. The purchase of civic number signs for each of the 4 created lots and a planning report fee payable to the municipality.
Thank you. Any comments from any of the members? John Selden?
Thank you, Mr. Chair. Through you, Ashleen, I really struggled with the wording and the phrasing about the retained land subject to a plan of subdivision. On page 120, particularly the second paragraph, rezoning to remove holding designation H2 by entering into subdivision regarding the retained lands. But condition 4 on page 20, subdivision of the severed lands and not the retained lands. What's correct? Is there a plan of subdivision required on the severed properties or associated with the severed property or just on the retained lands or not at all?
Through you, Mr. Chair, those would have been conditions and comments provided to us from the
BAM.
municipality.
Yes.
I simply just add them to the report the way they have had them written. So perhaps Nancy can offer clarification on that, or if not, we would have to talk to BAM.
Through you, Mr. Chair, I think that the anticipation is that the retained lands will be done through, any further development of the retained lands will be done through a plan of subdivision. So they'll be required to do that for any of the retained land development. I think that's ultimately what that condition probably speaks to.
When that is done, forgive me for interrupting, but so the condition is to get the H2 off means that the retained lands have to have a plan of subdivision.
Through you, Mr. Chair, the condition is rezoning of the severed lands to remove the holding zone by entering into a subdivision agreement with the municipality for servicing and adequate recognition that a plan of subdivision for the retained lands is not assumed. That would be a sub-agreement basically required with the municipality with respect to those retained lands. So we would simply ask at the time of final approval or registration of the final consent that an agreement has been entered into with the municipality and they can confirm that they're satisfied.
Okay, and forgive me for persisting with this, but those last two words of that phrasing that you just gave really confuses me. It says not assumed. What does that mean?
Through you, Mr. Chair, I'm not entirely sure, to be completely honest. The recognition that a plan of subdivision for the retained lands is not assumed. Maybe they meant to also say at this time or not assumed. I'm not sure. But there is no plan of subdivision at this time on those lands, so there needs to be, if that's the case, some sort of separate agreement or consent agreement or future agreement for the retained lands, if that's what they're choosing to do.
The 4 properties that we would be approving today aren't part of that subdivision.
No, it says specifically subdivision agreement
For the separate.
for the severed, retain. Oh, rezoning of the severed lands to remove by entering into a subdivision agreement with the municipality for servicing and adequate recognition for the retained lands is not assumed. So yes, it would be a sub-agreement then for those lots.
Or sub-agreement for the 4 lots.
Yeah,
Correct.
yeah,
That's right.
that's right.
And they're assuming the balance of the parcel would not be developed,
They developed, that's right.
Unless through a plan of subdivision would be made. Yeah,
separate process.
yeah.
Okay,
I struggled with that wording too, John. It wasn't an issue. I highlighted it, so.
Yeah.
Went over and over that. So the 4 lots are going to be subject to a sub-agreement?
Rezoning of the severed lands to remove the holding zone by entering into a subdivision agreement with the municipality for servicing and adequate recognition.
They need sewer.
So yes, there will be a consent agreement probably registered on title then. That's what they're looking for.
And the retained lands will require a plan of subdivision if they go ahead and try and develop those.
That's right.
that's right.
Okay. This is standard, is it? Just the phrasing on that is really bad, I think.
I've never seen a condition like this before, but I'm assuming that the municipality just wants some assurances from the applicant with respect to how the retained lands will be developed.
Does that seem reasonable to you?
It's not an unreasonable condition. I mean, through you, Mr. Chair, there's really, with the severance of these 4 lots, there's only really an access then that can be provided, almost like the size of a road. So really, the ability to develop the retained lands would only be done likely through a plan of subdivision.
Okay. May I ask, Mr. Gilvesi, is that your understanding of the situation?
We anticipated that it would be similar to the severances that we did across the road for another applicant. The 4 severances we assumed would proceed somewhat independently of the plan of subdivision, which is in the works. With the recent changes to the official plan, we are moving ahead with the plan of subdivision on the retained lands, which will be submitted very, very soon and go through the planning application process. The applicants would be willing to agree that the lands are going to have a plan of subdivision on it, but they would expect that these 4 severed lots would be able to proceed to construction as soon as possible, as long as they've agreed to develop the lands, retained lands, under a plan of subdivision.
Thank you.
Yep.
Thanks, Mr. Chair.
Okay.
That's a great help.
Any further comments from any of the members? Now, we're going to do each one of these under a separate motion.
I'll make a motion, we approve E 7621.
Moved by Rosemary, E 7621, seconded by John Selden. Any further questions? All in favor? John, are you
I beg your pardon, Mr. Chair. Yeah,
carried?
since I seconded it,
Okay,
You first and all.
I'll read this conditions at end of each one.
Yes.
Yes, that's. The decision rendered today for this application will be circulated within 15 days after the notice. There is a 20-day appeal period from the giving of the notice of decision in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of the notice, the provisional consent becomes final. The applicant has 1 year to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Ashleen Laverty at alaverty@algon.ca. A copy of the comment package is also available upon request and includes all correspondence received. Thank you. We'll now deal with E 77-21
I'll move, Mr. Chair.
by John Selden,
Second.
seconded by Dennis O'Grady. Any further questions? All in favor? It's carried. The decision rendered today for this application will be circulated within 15 days after the notice. There's a 20-day appeal period from the giving of the notice of decision, in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 1 year to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Ashleen Laverty at alaverty@algon.ca. A copy of the comment package is also available upon request and includes all correspondence received. Thank you. We'll now deal with E 78-21.
I'll move it.
Moved by Dennis, seconded by John Selden.
Yes.
All in favor? Carried. Decision rendered today for this application will be circulated within 15 days after the notice. There is a 20-day appeal period from the giving of the notice of decision, in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of the notice, the provisional consent becomes final. The applicant has 1 year to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy, excuse me, by contacting Ashleen Laverty at alaverty@algon.ca. A copy of the comment package is also available upon request and includes all correspondence received. Thank you. We'll now deal with E 79-21.
Make a motion.
Move it, Mr. Chair.
Second.
Moved by Rosemary,
I'll second.
seconded by John Selden. Excuse me. We went all in favor, sorry. The decision rendered today for this application will be circulated in 15 days after the notice. There's a 20-day appeal period from the giving of the notice of decision, in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of the notice, the provisional consent becomes final. The applicant has 1 year to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you'd like to be notified of today's decision, please request a copy by contacting Ashleen Laverty at alaverty@elgin.ca. A copy of the comment package is also available upon request and includes all correspondence. Thank you. We now have, excuse me, an application E80-21. Jonathan Gert, 2960 Thamesview Line, Municipality. Sorry, that's where the application is. But take notice that an application has been made by Jonathan Gert, 2640 Carroll Line, West Lorne, for consent pursuant to Section 53 of the Planning Act, as amended to sever lands municipally known as 29600 Thamesview Line, Municipality of Dutton Dunwich. The applicants propose to sever a parcel with a frontage of 68.751 meters, 225.56 feet along Thamesview Line by a depth of 120.551 meters, 395.51 feet, and an area of 8.12 hectares, 2.0 acres, containing 1 residence, 2 small sheds, and accessory building, surplus to the needs of the owner. The applicants are retaining 39.65 hectares and 97.98 acres proposed to remain in agricultural use. Applicants or agents and interested parties who wish to speak to this application, please introduce themselves.
Yes, Mr. Chair, it's Mark Coombs here as agent for the applicant, Mr. Giray.
Thank you. I'll now ask Ashleen to proceed with the conditions.
Thank you, Mr. Chair. The municipality of Dutton Dunwich has reviewed this application and they recommend approval subject to provided conditions. County engineering has indicated that this is not on a county road and as such has no issues. And the Lower Thames Valley Conservation Authority has no objection. This application for consent is consistent with both the 2020 provincial policy statement and complies with the County of Elgin official plan regarding lot creation for surplus dwellings in agricultural areas. As such, planning staff is of the opinion that the application is acceptable from a planning perspective and recommends approval subject to the following conditions. A digital copy of the draft and final deposited reference plan be provided to the County of Elgin. Solicitor undertaking to provide a copy of registered deed for the severed parcel once completed. Municipal addressing to be provided to Elgin County from the local municipality prior to final approval to the satisfaction of Elgin County planning. Additionally, it is recommended that the following conditions from the municipality of Dutton Dunwich be included as conditions for this consent. That a zoning bylaw amendment is in force and effect for the severed and retained parcels. That septic system review for the severed parcel has been completed. That municipal drain reapportionments have been completed. That a mutual drain agreement under Section 2 of the Drainage Act has been provided to provide a legal drainage outlet for the newly created residential lot. That 2 hard copies and 1 digital copy of the registered survey have been provided to the municipality. That taxes are to be paid in full. That a 911 sign be established for the retained and severed parcels. That all Dutton Dunwich planning fees set out in the fees bylaw be paid to the municipality. And that the solicitor provides an undertaking that a copy of the registered deed for the severed parcel, once the transaction has occurred, will be provided to the municipality. Thank you, Mr. Chair.
Any comments from any of the committee members? Yes, John?
For you, Mr. Chair, I'm just concerned to Mr. Coombs. Are you satisfied and is your client satisfied that the water is okay there? E. coli just is there are two analyses were done. One was not great, one was okay, but is that well adequate?
Through you, Mr. Chair, thank you for the question. I've spoken with my client and the people who are currently living in the house. My understanding is that they've been living in the house for some time and are currently residing there and consuming the water. So I don't believe they're concerned. But obviously the fact that the water tests have not come back completely clear is of some concern.
Thank you.
Yes?
Chairman, what buildings are left? Did that, looks to be an old chicken barn. Did that get torn down?
Through you, Mr. Chair, I can answer that question. I'm not sure if Ashleen or anyone else can enhance that photo, but I can tell you that photo that was provided as part of the materials is a bit out of date. There's a building that is to the northeast of the parcel that's sort of, if you can see, oh, okay, we're gonna get zoomed in here. This, maybe we can zoom in a little bit more, but the building in any event that's to the northeast of that severed parcel has been removed completely.
Yes.
And another building that I understand was in a bit of a state of disrepair has also been removed. So now there are only the residence itself, a small metal shed, a small garage, and then a small metal building, all of which are in an adequate state of repair, and none of which are straddling the lot lines, all of which will have an appropriate setback from the proposed lot lines.
And a further question, so the buildings on the west side of the property, what are they and what use is the current owner going to make of them?
So the buildings, there's 1, 2, 3 metal clad buildings and then a concrete structure, which are remaining. I believe they're just farm accessory buildings that are used for storage. And I believe the current owner is going to continue using those as he's farming the parcel.
Yes, go ahead.
Mr. Chair, if I may, to committee member, Mr. Sullivan, just note, and actually for all the committee's benefit, total coliforms are not likely to cause illness. But their presence may indicate a more contaminant, more harmful microorganism may be present, irrespective, and most importantly, E. coli, because both sample readings are 0. That's the most important element with which water quality is regarded in water supply. Containing E. coli is the most concerning component to be focused in on. So in this regard, because the 2 water samples show no presence of E. coli, Public Health Ontario would regard it to be safe.
There was no E. coli shown on that first analysis?
Coliform counts were identified on both.
Coliform on both, but no E. coli on the first?
No E. coli.
Sorry, I thought there were.
Was there not a condition put on by the municipality that the chicken barn was to be a separate resolution on that? I'm just looking for that. I thought there was a concern of theirs that,
Through you, Mr. Chair, I assume the chicken barn is the really long skinny one, right?
yep, it's by the old barn.
That one's actually already, or is that the one on the retained parcel you're talking about?
No, it's on the retained parcel,
Oh, okay.
the farmland.
So there's no conditions speaking to that, but in part of your correspondence, there's actually a map that shows sort of like the applicant circled in pen of the buildings that had been removed already, that just our aerial image hadn't caught up with. I'm not sure about the chicken barn, and then I don't see a comment related to it.
Excuse me, through you, Mr. Chair, page 219 of 224.
Yes,
Actually he's referring to, and his notes on page 218. Part of the deal, I had to take down the 2 buildings circled below. So it's dealt with.
yeah, the buildings are down, but I thought the municipality put a condition for the on the retained farmland, but maybe they didn't,
Condition on the retained farmland.
from Dutton Dunwich.
I have a question.
No, I got it right here, that all barns capable of holding livestock or are in disrepair on both the retained and several lands be removed or decommissioned. So that condition, that's one of the conditions they've asked to have put on there.
What page did you find that on?
206. Yes, the buildings on the severed land are removed. They've been removed. The one that divided the lot line was divided by the lot line. And that they've been, but this is just the barns that are on the retained farmland.
Sorry, through you, Mr. Chair, what condition are you noting?
Yeah.
I don't see it on 206.
Yeah.
It's on
Saw it as well.
206, 205? Oh, God.
No, it was on there, I remember.
Oh, through you, Mr. Chair, I see it. So they added that condition then.
Yes,
Okay, I see that, okay.
that was the second motion, wasn't it?
Yeah, so this is the actual council resolution, so they must have added it to the staff's report.
Yeah.
So we'll ensure then that J is added then to the conditions
Yes.
as amended.
That was one of their conditions in that one, so that should be added in our condition.
Yes, absolutely, so we'll make a note of that.
Any other concerns? Jack?
I have clarification if I might. Let me scroll back to it, page 213, the municipal appraisal sheet. Confused, number 4, does the proposal conform with all requirements of the bylaw? No. Comments, as a condition of severance, a zoning bylaw amendment is required to rezone the severed and retained parcels. The severed parcel will be rezoned special RS zone. Okay, the retained parcel will be rezoned to A2 to allow an existing dwelling. However, it will
Not be allowed to.
not be allowed to be severed. So there, just to clarify, it's gonna be rezoned so that they can build on that farmland that's being retained. They can build. That's the way I'm reading it.
It says existing dwelling, so no, there's an existing dwelling on that
On
property.
the retained portion,
Yes, that's what it says.
I'm looking at the diagram up on the screen, the severed portion has the dwelling on it.
Yes, but there may be two dwellings on this property.
I'm looking at the retained portion, I'm not seeing a dwelling anywhere and no mention of it in the application.
Through you, Mr. Chair, there is no additional dwelling on the retained portion.
No.
That's what I thought.
Yeah. Our understanding is that the rezoning is going to be required, as it usually is in these types of surplus farm dwelling severances, where the severed parcel is to be rezoned to a rural residential use, and the agricultural land will be rezoned so as not to permit the construction of a new residential
That's
dwelling in
right.
the future.
Yeah.
That's what's normally taken.
Standard, yeah.
That's right.
I just confused when it said to allow the existing dwelling when there isn't one, not according to the information provided.
Right, there is no other dwelling on that. Any other questions from any of the members?
Move.
Moved by Dennis O'Grady, seconded by Rosemary Kennedy. All in favor?
Mr. Chair, we'll make sure that that includes the condition as amended, correct?
Yes, please. Condition J has to be on there.
Yep.
That was on Dutton's memo coming.
Yep.
Okay. The decision rendered today for this application will be circulated within 15 days after the notice. There is a 20-day appeal period from the giving of the notice of decision in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 1 year to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Ashleen Laverty at alaverty@elgin.ca. A copy of the comment package is also available upon request. Includes all correspondence received. Thank you.
Thank you, Mr. Chair, and thank you, members.
Thank you.
Thank you.
Okay. We have done the one that's review and potential approval of 2022 Land Division Committee meeting dates. And refresher training for LDC members, we've discussed that. Any other business? Ask for a
Motion adjourned.
motion to adjourn. By Dennis O'Grady.
Passed.